I love doing these business videos because what's important about having a writing career is you have the artist brain and the business brain, and they have to be able to work separately to create a longevity to your writing career. So today, we're going to talk about a topic that's very important to every writer, and that's copyright and intellectual properties, which are assets both for protection and future financial growth. If you've ever wondered how to protect your work, what your rights are as a creator, or how to avoid common copyright pitfalls, then you've come to the right teacher. Am I right? Am I right? So, we are indeed going to be focusing on boom how to protect your writing, copyright basics every author must know. More importantly, we're going to break down the essentials of copyright law in simple terms, explain how to safeguard your writing, and go over some common misunderstandings, like what constitutes fair use or when a work is considered to be in public domain. By the end of this video, hopefully you'll have a clearer understanding of how to navigate copyright as a writer so you can protect your own work and focus on your creativity while feeling secure about your rights. You know what I'm saying? You know what I'm saying? So basically, having over 20 plus years of experience in the entertainment industry, from being an illustrator with comics to having music and a career in the music industry to my stand-up comedy, all the way to the writing screenplays and being in film and television. Copywriting is very important because, well, there's copyright, patent, and trademark, just for the record. But today we are going to focus mostly on copywriting. Copywriting is not to protect the every element, and we're going to go over that. Like, for example, if you copywrote your rules to the game, you can't copyright the fact that you have to roll a d6 or your piece goes around the board. But what you do copyright, right, basically, is the verbiage in order that you're utilizing. So if you wrote, you must use a d6 to move your meeple around the board 4 spaces, that dialogue, that copy as it's known, is what's copywritten. But you don't own those words. You don't own the mechanics of something. You can't own. For you to do that, that's a patent. You got to go for a patent to control the process, or more importantly, the mechanics. But the mechanics of something in a patent can be altered or changed. For example, you can make a refrigerator, and I can make a refrigerator. Or how a refrigerator works, etc., etc. But let's get into the essentials of copyright law in simplified. Well, yeah. Let's go over this. The essentials of copyright law in simplified. Simple. Dialogue simplified. Right? Did I spell that right? I think I spelled that right. I'm going to consider it spelled right. I feel good about it. The essentials of copyright law simplified. Okay. Copyright laws give you, the creator, exclusive rights over your work. This means that as soon as you create something original and fix it to a tangible form, like writing it down or saving it on your computer, it is automatically protected by copyright. You own the right to reproduce, distribute, perform, display, or create derivative works based on your original creation. Now, for example, if I did it on my computer, the file itself is dated with basically a stamp, a timestamp. So if you and I went to court and you had a timestamp and I had a timestamp, ultimately the one with the latest, the oldest timestamp will win the argument. Who owns what? If it's something that's written down, it's very difficult to prove when you wrote it down on a physical piece of paper. If you notice, I do some live videos of me doing outlining on just random stories that I make up. If anyone takes those and I really wanted to, I could be like, hey, here's a video proving that I came up with the information before you, etc., right? But there are legal ways to just get rid of that conversation, and that's something we are going to go over. So, yes, you can just create it, and you do technically own it. Yes, you can make it on your computer and have the timestamp, and technically that secures you. But legally, there are other ways to get around it, and whoever has that legal representation of copyright date of creation traditionally would win the case if it ever went to court. But there are a few key points to remember. Okay, just like we sort of went over it, automatic protection. You don't need to register your work for it to be protected by copyright law. It is automatically protected upon creation, especially if it's on a computer or if you record it and stated, whatever. Now, believe it or not, the duration of a copyright generally lasts for the life of the author plus 70 years. After that, the work enters the public domain, meaning anyone can use it freely. So if I copyrighted something today and I live another 30 years or 40 years, let's say 50 years. Let's say I live another 50 years. The copyright is good for 50 plus 70, which is, what is that? That's 12. So 120 years the copyright would last, right? So it's my 50 years plus another 70 years. So from its creation, that's 120 years. So, basically the longer you live, the longer the copyright. Okay? However, you should speak to a copyright lawyer because you might be able to transfer the copyright itself of ownership. But again, Mickey Mouse, believe it or not, is anyone could use Mickey Mouse now. All right. 3, fair use. Not all uses of copyrighted material require permission. Fair use allows limited use for purpose, such as commentary on something, criticism, or education. However, determining fair use can be complex. So it's important to be cautious. We are going to go over a couple of these things in greater detail. I'm just sort of giving you 5 quick points to remember as we discuss it, okay? Public domain. Public domain works in the public domains that the fact that works in the public domain are free for everyone to use. This includes older works whose copyright has expired or works explicitly placed in the public domain by the creator. That's why you could use anyone's classical music in your YouTube videos because Beethoven is dead plus 70 years. So it's public domain. All right. And finally, registration. While registration isn't required, it can be helpful if you ever need to enforce your rights in court. Registering your copyright makes it easier to prove ownership and take legal action if someone infringes on your work. Before we go deep into this, just know one of the things that makes it really easy for me when I do copyright is I just sort of copyright my works of. So it's like Thomas J. Like, for example, all my lyrics for music is lyrical works volume 1 of lyrical works of Thomas J. Bellezza volume 1, and that's like all the lyrics I wrote up to a certain point. And then as I build up more lyrics and I'm getting ready, and it like when I was playing in the industry, when I knew songs were going to be more public and potentially we were going to record them, I would do volume 2 and then volume 3, volume 4. Okay. Then when it came to the music, I did the same thing. I would do the composition because I would write everything out and I would transpose it, and I had sheet music, and I would just do the composition works, the musical composition works of Thomas J. Bellezza, volume 1. And I did that. When I did comedy, I would do the same thing. I would create a bunch of jokes, refine them, and then I would basically transcribe them all, write them all down, and then I would just do the comedic works of Thomas J. Bellezza, volume 1. So as an author, what do you do? Well, if you write out a bunch of treatments of your works, you can copyright your treatments that have a general protection on them. So it wouldn't be a protection on the book that you copyright, like the full manuscript, but you could create treatments and or outlines within those treatments and copyright your volume. So I could do the authorial work or written works of Thomas J. Bellezza, volume 1. And then on top of that, you can, in addition, you can register the manuscripts as you finish them. I wouldn't do a manuscript on a 0 draft, first draft, or even a second draft. I would do it on a completed draft, like a draft where you feel confident you're going to publish, because you're allowed to change 20% of a copyrighted item without having to recopyright it. But this is why I do the volumes, because they just protect large groups of it, and I don't have to keep copyright and everything. And treatments and outlines are good because, in a sense, they protect your story, like basically your characters, their arcs. That's what you're copywriting. You're copywriting their arcs and their movements and growths, the character names, etc., terms, terminology. That's why Dungeons and Dragons, when they were TSR, now they're Wizards of the Coast, or Hasbro, but they couldn't use hobbits, so they created halflings, and then eventually they created Kenders, because Tolkien and his family owned it at the time that D&D TSR created the hobbits. They were like, oh, you can't do that, so they made them halflings. So that's an example of Tolkien owned the term hobbit because that you're copywriting that. So there's an example. All right. Now, of course, I always recommend always doing your own research when learning new information so you can deep dive into understanding it, because that's how we take knowledge and refine it in our minds. Hey, how to safeguard your writing. All right, let's do it. The cat jumped up before I started filming, so cat hair is like floating around everywhere. So protecting your work, that's an aside. Protecting your work involves more than just understanding copyright law. So here are some practical steps for you to safeguard your work. 1, register your copyright, which is basically what we just said. So, well, copyright is automatic. Registering your work with the U.S. Copyright Office or the appropriate agency in your country, county, or existence provides an extra layer of security. It makes it easier to enforce your rights and pursue legal action if somebody does indeed infringe on your works. Oh, yes. All right, we got more. Okay. Now, by the way, if you want me to make a video about the copyright process and like how to walk through it, just let me know, and I'll be happy to do that. Let me know in the comments below. If I get enough people that are like, hey, this would be a good video, maybe I'll make it. All right. 2, keep detailed records. This is so important. You need to maintain records of your drafts, notes, and other documentation that shows the evolution of your work. This can help prove and provide the necessary required safety nets that you are the original creator in case of a dispute. So if you don't have it registered and somebody does register your work, you can be like, look at all this. I have everything organized. This is something I do extensively. I have tons of dated information and folders and hard copies of stuff, and I have a major history of it too, because when I started in comics, that's where a lot of my epic fantasy stuff started. It was comic books, and then I almost worked for TSR. There was this like small moment I almost started creating the world that I made in the comic book world and created a fantasy world for TSR, but they went bankrupt and were sold to Wizards of the Coast. And then a long time ago, man, I feel so old sometimes. So I have a history of my characters existing even before I became an author. So, or I should say a full-time author. All right. Use digital tools. Now, platforms like Google Docs or cloud storage, or I should say, so platforms like Google Docs or cloud storage services automatically timestamp your documents, which can be useful for establishing a timeline of your creation. Additionally, services like blockchain-based copyright registration can provide added security. Now, of course, if you do a YouTube video and you talk about it, or you show snippets from it, or you discuss some of these things, they become documented variations of your copyright. Back in the day, we used to do what's known as the poor man's copyright. We would just put it in an envelope, mail the envelope to you, but they stamp it. That is a poor, and then you don't open it. That's a poor man's. Doesn't necessarily always work, but it is good if you're light on money. Watermark and metadata. So if you're sharing excerpts or drafts online, consider adding a watermark or embedding metadata in your digital files. This helps ensure that your authorship is recognized, even if the file is shared without permission. Okay, so that's another way you can protect yourself. Contracts and agreements. When collaborating with others or hiring freelancers, make sure to use clear contracts that outline the rights and responsibilities of each party. Specific, who owns the right to any work produced. All right, so this is something I could definitely talk on. When I was hired to write screenplays or a pilot episode or something like that, there is story by, like, so if somebody was like, "Hey, I have this story and I want it to be about XYZ, but I don't know how to write a script." They would hire me. So it'd be story by and then written by me. So I would have a written by credit and they would have a story by credit. Okay. So, or screenplay written by. Yeah, because written by is, I also own the story. So those are important elements when it comes to who gets the credit for it, because on paper, one person owns the story and the other person, if I write the script, I technically have ownership on the screenplay, right? But they have ownership of the story. So they still I need my permission to utilize that screenplay in whatever fashion they do. So according to the Writers Guilds of America, you know, you can't just take my screenplay and use it and then cut me out of the picture and take me off that paper because I wrote it. But you can go and hire another person to rewrite your story. They just can't rewrite my screenplay. They can take elements of it because the story by, but they can't just be like, we're gonna change this little scene and then put my name on it. Like you can't do that. So contracts and agreements help with the responsibility of basically defining who owns what and who produced what. It's the same thing with writing a novel. If somebody hires me as a ghostwriter, I am the writer. That manuscript is mine, but their story, they own their story. So I get ownership of the writing. And like, if the book became a movie, I would be a part of the money exchange. Give me money, money, money. All right. Monitor your work. Now, you should regularly search your work if you're paranoid, like some of us, online to see. I'm not really paranoid. If you are worried, regularly search for your work online to see if it has been used without your permission. Tools like Google Alerts or plagiarism detection services can help you stay vigilant and take action if needed. There are things where some people will put like a book on Amazon and then someone will buy those books and then they'll resell it. That's different. But if they take the works and say they wrote it and it's literally the same book cover, it's the same manuscript, now that's plagiarism. But anyone could do resale as long as they buy it. They could resell. You know what I'm saying? But if they take all the data information and still use your name, and then you're just buying through them, like they actually published it, but it's like you can get in trouble for that. So, but anyway, following a lot of these 6 things will help minimize the risk of unauthorized use of your work and ensure that your intellectual property remains protected. But again, I always recommend do your research, so you can understand the knowledge you grow. So let's talk about some common copyright misunderstandings. All right, we're almost done. We're almost there. So these are just basically some misconceptions and about copyright law, and these misunderstandings can lead to mistakes that cost you, the writer, the rights or leave their work unprotected. Now, so here are a couple of them. So really quick, copyright needs to be registered to be valid. Many people think that unless you register your work, it isn't protected by copyright. In reality, copyright protection is automatic as soon as you do what? Create a physical or tangible item. Registration is optional, but is there mainly to provide additional legal benefits if you need to enforce your rights. The other thing is fair use means you can use anything. This is a misconception. Fair use is often misunderstood as a free pass to use any material without permission. In reality, fair use is a complex doctrine with specific purposes like commentary, criticism, and education. Simply labeling something as fair use doesn't guarantee you won't face legal issues. We were going to talk about fair use, okay, mostly because people on YouTube want to use some stuff. So just right off the bat, just a quick aside, commentary is the reason is because if people write reviews on something and they use like, I don't know, a quote from, or they describe the plot, technically, if this wasn't a thing, they could get sued. But because it's under fair use, I'm allowed to have thoughts and commentary and be like, yeah, I was watching Star Wars and like this character Vader came out and they just stood there while their stormtroopers took out all the rebels on the ship while they were trying to get Princess Leia. I'm basically telling a story. I'm talking about a story. And if I make money on that interview, or if I make money on my commentary on YouTube, that would be, oh, copyright infringement. But it's not, because it's commentary on the idea. It's my opinions or my thoughts. And that allows it to be fair use. That also includes criticism. Okay. You're allowed to say something sucks, but the education is something like I do. Like, for example, I'm starting a prose playlist, right? So the prose playlist is me looking at, say, a page or two of an author and then examining and dissecting and analyzing their prose. Another thing I'm doing is I'm going to start a live series where I take a page or a passage and then I rewrite it in my voice to show you like the different styles of writing, or how you could take something and how you discover your own voice. So it's going to be like a learning thing to show how to take something and elevate it and grow as a writer. Those both fall under fair use because they are for educational purposes. I'm not selling the works. I'm not going to rewrite the passage and be like, buy my book, it's called Game of Thrones. Or Game of Thrones. All right. Anything on the internet is free to use. This is a misconception because just because something is publicly available online doesn't mean it's free to use without permission. The author still retains copyright unless they explicitly waive their rights or the work is in the public domain. Always assume that online content is protected by copyright unless stated otherwise. Okay. 4. Public domain is the same as free use. No, it isn't. While public domain works are free for anyone to use, it's important to understand what qualifies as public domain. Not all old works are in the public domain. And just because something is easily accessible doesn't mean it has lost its copyright protection. Tolkien, his estate, his family, his kids, they were in a huge legal battle with not Peter Jackson, but I forget this. I think the studio that did the Lord of the Rings movie specifically. They were in a huge legal battle over it. In fact, if you do a little bit of research, you'll see that Amazon couldn't technically use the Silmarillion completely. That's why a lot of it is sort of like a play on the Silmarillion and the history of the world of Tolkien, because of the rights. And like I said earlier, you can sometimes the copyright can be you can give the copyright to family or whatever the case may be. So that's something to really look into, because not all public domain is free use. And finally, number 5, changing the work means it's not infringed. This is a misconception because modifying a work, whether it's changing a few words, adding your own content, or creating a parody, does not automatically mean you're in the clear. Depending on the degree of modification and the context, this can still be considered infringement unless it falls under fair use. So again, like I said, I'm going to have a live videos where I take a chapter, or not a chapter, a page or a passage, and I rewrite it in my voice, because I'm educating you. I'm showing you how I'm doing it, but then I'm not going out and selling that or using it to sell and make money. The other thing is, going back to writing, like with screenplays and stuff like that. If I write a screenplay and you change and you get hired to rewrite that work, my name stays on it unless you change more than 20-25% of the script. It's the same thing with directors. If a director comes on and they have to do reshoots, The original director maintains the title, the credit, unless 20% or more of the movie has been adjusted. Okay. All right. Now we're going to talk about what constitutes fair use, or when is a work considered to be public domain. So we're going to first focus on fair use. Okay. So fair use allows for limited use of copyrighted material without needing permission, typically for purposes such as criticism, commentary, news reporting, teaching, scholarship, or research. However, how do we determine fair use? Well, there are four things you can do to figure out. The first one is purpose and character of use. Is the use transformative? Non commercial educational uses are more likely to be considered fair use. Example, using a short clip from a movie in a classroom setting to analyze its themes is more likely to be considered fair use than, say, showing the entire movie in your classroom and charging $5 a person. Okay. Two, nature of the copyright work. So, using factual works is more likely to be fair use than using highly creative works. Okay. So, example, quoting a small portion of a biography for a research paper is more likely to be fair use than using a portion of a fictional novel. Okay. Okay. Because you can, it's very touchy, very touchy. Just saying. Three, amount and sustainability. Using a small, less significant portion of the work may favor fair use, but using the heart of the work may not. Example, quoting a few lines from a book to support a point in a review is more likely to be fair use, whereas reproducing an entire chapter would not. I read this book today, and this chapter, and then you just show the whole chapter. Now you're sort of teetering. Effect on the market. So if your use negatively impacts the market value of the original work, it's less likely to be fair use. Example, if you share an entire ebook online for free, this would negatively impact its market value and is unlikely to be considered fair use. Okay. So that's important to know. Let's talk about public domain. There's three things to stand out about this, but public domain traditionally prefers to works that are no longer under copyright protection or never were, making them free for anyone to use. Now, there are three major things that will help you understand expired copyright. So, generally, works enter the public domain 70 years after the author's death. For older works, different rules may apply depending on when or where they were published, because the copyright laws have changed over the years, right? The other thing is no copyright protection, right? Some works, such as those created by the US government, are automatically in the public domain. So that's interesting. I will say this again, going back to patents, Elon Musk released all his patents to the public because he wants people to take what he has or his companies have created and leapfrog on them and be like, oh, how do we take this and make it better? He doesn't make money on the designs of his inventions, his company's inventions. Three, dedication by the creator. So some creators choose to place their work directly into the public domain, waiving their copyright. So that's basically what Elon Musk did with his patents. But I could write a book and be like, it's public domain. You have that control. You're allowed to do that. All right. So knowing whether work is public domain or qualifies under fair use will help you kind of work around the buttons. With that said, I have a quick final thought. Copyright and intellectual property can feel overwhelming. There's a lot going on with it, but understanding the basics is essential to protecting your own work and your own rights as a creator. Remember, your writing is your intellectual property, and it deserves to be treated with same respect as any other form of valuable work. So take the time to learn about copywriting, registering your creations, and know what steps to take if your rights are infringed. By arming yourself with this knowledge, you can confidently share your creativity with the world, knowing that you have the tools to protect what's yours. Your creativity is worth defending, and understanding your rights as an empowering step towards making your mark as a writer. I want to say one other thing. When it comes to intellectual properties, this is one of the 8 assets you can own in your existence. All right. The stocks, bonds, mutual funds, intellectual properties, real estates, businesses, IOUs, which means I owe unto, meaning I lent you money, pay me back plus interest. And then, of course, commodities, which is like coffee, gold, beans, stuff like that. Okay. Intellectual properties include copyright, patents, and trademarks. Trademarks is like owning like an image or something like a band's logo, like Black Sabbath. That could be trademark. Walmart, the logo of what is trademark. Patents are designs or processes. And then your copyrights are what we kind of went over today, which are just intellectual properties. They are thoughts or ideas that are written out and exposed or articulated on a page or a computer or whatever. They are readable, and they are assets because you own them and they don't cost you any money to own or maintain. That's what makes a liability versus an asset. A liability is something you have to pay to maintain. So a house that you own and live in, you have to pay to maintain that. However, if you own a house and rent it out, or you own a house and sell it, it's an asset. So that's a very small difference between the mindsets, right? So your intellectual properties, why are they assets? Is because you own it for free. Okay, it's yours, and you can allow people to use it, buy it, sell it, maybe convert the medium, the format. So like a book could turn into a movie or television. A book could turn into a comic book. Like you could take a novel and be like, I'm going to make it a comic book. Believe it or not, taking the novel and turning it into an audiobook is a transfer of medium. And that's, you own the intellectual property, so you own whoever works on that. All right. With that said, next video in this series, we'll be negotiating contracts with publishers. We will cover key contract terms like advances, royalties, and subsidiary rights, and offer tips for negotiating favorable deals. Question: have you ever faced a copyright issue or worried about someone using your work without permission? Share your experiences or concerns in the comments below. Let's help each other navigate this complicated but important aspect of the writing world. Let's work as a team, work, grow, rise together. If you like what you saw today and you haven't done so already, please subscribe and hit the like button and bell so you don't miss out. With that said, I had a lot of fun. Keep developing the right mindset. I'll see you next time. Bye.